Hey everyone, I'm Melanie from Streamlined Legal, where we help law firms get the most out of their practice management software. And tonight we're talking about who's using that practice management software, particularly the intake software. A couple of weeks ago, specifically on June 7th, the ABA put out an opinion that had to do with using non-attorneys in the intake process. Now, they didn't call it that. They called the opinion Responsibilities Regarding Non-Lawyer Assistance. But the opinion goes on to speak specifically about staff that is helping you with the intake process. So we're talking about things like collecting documentation and running conflict checks and all that great stuff that goes along with getting people to hire you, essentially, and that sales process that we like to refer to as intake. And so the ABA put out an opinion on that, and it focused mostly, of course, as most ABA opinions do, on the model rules. It did not indicate any particular fact patterns necessarily. Sometimes they will include those kinds of things as to why they're issuing this opinion or something like that. This one did not include anything like that. It just talked about the responsibilities that the ABA saw as attorneys having in dealing with non-attorney assistance, particularly in the intake process. And I'll spare you having to read the 4 pages, but basically what it comes down to is that they do allow the use of non-attorney staff in the intake process for a lot of different tasks, assuming that, and there's these 2 caveats, assuming that the things that they're doing would not be considered the unauthorized practice of law in your particular jurisdiction. That's number 1. And number 2 is that the prospective client always is offered an opportunity to discuss the fee agreement and the scope of the representation with the attorney. So the good news is that, of course, the ABA didn't have anything negative necessarily to say about the use of those team members, assuming, of course, that they were able to follow some policies and procedures and be guided by attorneys and things like that, and they didn't have any unauthorized practice of law. But what I found particularly interesting is this use of the word always when talking about offering the potential client an opportunity to speak to an attorney about the fee agreement or the scope of the representation specifically. And so the fact that they used the words always have to be offered an opportunity, it started me thinking about best practices and how we might implement these kinds of opinions into our own practices. Now, of course, just with every ABA opinion, we want to take a look at the rules that our state has actually adopted and find out, how our jurisdictions are going to be handling this specifically. But if we're looking at the ABA's opinion, they use that word always in offering this opportunity for the potential client to speak to the attorney. So when thinking about best practices, it made me think, maybe this is an opportunity for us to get out those engagement letters that maybe we haven't edited in quite some time. And maybe it's a great opportunity for us to look for ways that we can document the fact that we've offered this opportunity to a potential new client. Now, again, it does narrow it to the idea that they have the opportunity to speak to an attorney about the fee agreement and the scope of representation, right? So it's not necessarily everything under the sun, but obviously those are 2 big ones. So I would love to share more with you about this opinion, but I want to make sure just to get out the word that with this kind of language in the opinion, I do think it's a smart idea for us to take a look at our engagement letters, maybe start including some type of language in there that the client can sign or initial or include that basically says they were offered that opportunity to speak with an attorney regarding the scope of the engagement or the fee agreement. Because as we all know, we can offer up that testimony in court if it ever came down to it, but the best evidence is going to be something in writing. And so if we have that, I just feel like that would be a great protection for us. And to be honest with you, from all the attorneys that I know that are using non-attorney salespeople in their intake process, typically that is something that they either offer or are open to, the idea that there are some questions that that person may not be able to answer, specifically with respect to the agreement and interpreting that agreement or that contract that we have with our clients, and do offer this anyway. So it's not like it's a huge change in the way that we're doing business necessarily, but it may be a change to our documentation that we're using to conduct that business. So The nice part about the opinion is that it did offer up some very concrete examples of things that they thought a non-attorney salesperson could do versus things that they could not do. So that offered some nice guidance. And if you want to hear more about that, I would encourage you to go ahead and subscribe to the podcast, Your Law Firm is a Business, Take It to the Next Level. Go ahead and look that up on your podcast app. Subscribe, because I did just record an episode today with Mark Homer from GNGF where we do go further into detail about this opinion and talk more about the examples of things that they can and cannot do according to the opinion. And I think that if you are using a non-attorney salesperson, that will be really, really helpful. So that episode should come out in about 2 weeks, but go ahead and subscribe to Your Law Firm as a Business, Take It to the Next Level. That way you won't miss the episode when it does come out. Thanks for joining me tonight, guys. Have a great, great evening.